Hi friends from around the world. We talk about unitary patent today. We didn't talk about unitary patent so far. I may remind you that the previous video are on the Unified Patent Court, so the litigation system which has to do, yes, with the European patent, but not only. If you haven't done so, I invite you to revisit these UPC videos, which have an important first part before going to the unitary patent. Now, why are we talking now about a European patent and why I'm saying this? Well, you know, the proceedings in front of the EPO are the same for unitary patent or the European patent. European patent being for 30-something member states of the European Union. Some of them are contracting member states of the European Union, others of the European Union patent, of the unitary patent, others are not. So we have 38 member states of the European patent, I think it's 38, and you have the 27 member states of the EU, and you have the 17 member states participating already as contracting member states in the unitary patent. Then we have a total of 22, the 17 are inside the 22, potential contracting member states, so 5 have signed up but not deposed the ratification document. So this is the overall picture. Now, when can you apply for a unitary patent? Well, you know the proceedings before the EPO, they are the same. So you file for a patent without saying the geographical extension you are required to, requested to say at a certain moment. And then the proceedings go, so the EPO will check the novelty, the inventive step and the industrial application just as before. And then at a certain moment, after 1 year, 2 years or so, that is the average, the EPO will grant the patent eventually. So then it is that you decide about the geographical extension. And then at that moment, if, and I think so, if the unitary patent is operational and the Unified Patent Court is set up and operational, then you will be able to request the extension unitary patent. And the unitary patent, you will get then the extension which you have for the contracting member states. So, is that then too early if it takes 2 years in order to get to the unitary patent? So why we are talking about now about the unitary patent? Well, as you know, the unitary patent or the unitary patent system you can ask for once it is already operational. So as for the unitary patent, you will be able also to ask for as from beginning 2023. Why is that? Well, the patents which are now being processed or which have been filed already a year ago, they may be granted in March 2023, right? 2 years, more or less, processing time. So then, if, as I think so, the unitary patent is operational, you will be able to ask for the unitary patent. So we are talking here about February or March 2023, when this will be possible. So it is not as far away as you thought probably at the beginning of the video. It is a bit advanced, but you will have to get acquainted with the system in order to know before what to do. So you will have to build up the knowledge on the unitary patent in order to advise rightly and righteously your client, right? So that is what it is about here. So we are not too early, but you're building your right at the spot, I would say, right at the moment in order to get this done. We are here in May 2022 when this video has been done. Now, with regard to comparison of cost, which is today's menu, comparison of cost between the European patent and the unitary patent, well, that is not an easy task to do. Because you have on one hand the different geography. As I told you, we have the unitary patent now with 17 contracting member states. It may be up to 22 because all of those 5 have signed up. But it is not the 25 or 27 member states which we have in the European Union. So you can compare the unitary patent with 17 member states, with 22 member states, with 27 member states. So there is a problem in comparison, a certain problem with comparison with regard to the geographical extension. And at the moment of requesting a unitary patent, you will get what is the extension, the geographical extension of the unitary patent at that moment. So it may be that from the 17 to 22, the 5 member states, potential contracting member states, are not going all at the same time. So if you have 17 member states at that moment, you get the grant for 17 member states. The unitary patent will have an extension of 17 member states. If at that moment we have 18, so it's 18. But at a later moment, it becomes 19. So the 19th contracting member states will not be part of yours if you have asked before joining that member state into the contracting member states basket. Is that clear? So you get what is the geographical extension at the moment of designating the unitary patent. So another issue is with regard to comparison of costs, right? You have, and that you know, you have the 20 years of maximum patent validity, right? We have some SPC possible, but leaving that aside, you have these 20 years. But that doesn't mean that every patent has a validity of 20 years. No, it is just what I see from the EPO website. There's an average of 5 years that the patent have a validity. There are patents which goes up all the way to 20 years. There are patents which goes less than 1 year or 2 years. But the average, and that is something you have to have in mind, the average validity of the patents is not more than 5 years. So you will have to see the comparison you will have to do is afterwards to analyze your client's portfolio. Now, there is another issue before we come to the actual cost, right? There's another issue which is a rule of thumb what you should retain, and it is the same as we have for the European trademark and the design system. So it is a conceptual part where we say, well, if it is more than 3 member states, you will have for the unitary patent, for the European trademark application, or for the community design. So it should be cheaper to decide for a European title. meaning that a rule of thumb comparison for you is clear if your client wants the protection for more than 3 member states, so 4 contracting member states, then the European patent is the unitary patent is cheaper on the fees, right? Another issue is what do you want to compare with? So you have the fees, the official fees. I will come to that in a moment. But then you have also the attorney fees, the translation fees, publication fees of some member states when you put this all into the basket. So it will change a bit the picture. I will come to that as well. So let me introduce you to the European patent website. Well, the tables which you will see now, they come from that website, and that is useful. So you may also want to look up the EPO's website, where you can perhaps find also some information. And here on the screen now, you see on the table, you see the fees of the unitary patent and compared to 25 member states in the European Union. And you see the first year is free, and you see that if you compare the unitary patent and the 25 member states, you will see that the increasing concept, so the first year is free and the second year is cheap, and the 20th year is the most expensive one. So it goes up in the way, and it goes up for both for both systems, so to say. But you see that if we take into account 25 member states, so that is a bit beyond the top, I would say, you will have a massive amount of less expenditure, 35,000 to 160,000 in the European patent. So that is a massive amount. I don't know how much of the patent filers will go up to the 20 years, as I said, is doubtful, and how many will have 25 member states, that is doubtful as well. This is the big picture, so to say. If you go for the full menu, then you would be much better, as a no-brainer, so to say, to go for the unitary patent. So this is based on the fees for January 2020. So it may go up. So there's the committee of administrative, the administrative committee of the EPO of the unitary patent system, which will have to decide on the fees for the actual fees. So. And then we come to a second table, which is important as well, and which takes now into account a bit the rule of thumb. And here it is on the screen. We have the comparison between the cost of unitary patent and 4 contracting member states' cost on the other hand. And also here, you see at the end there is less fees for the unitary patent, and let me see how is it composed. It takes into account not only the fees but also the costs associated with the validation and maintenance of a classical European patent. And these costs can be considerable and typically include translation costs incurred for validation and publication fees available at the various national patent offices. as well as fees charged by attorneys or other service providers for validation and the payment of national renewal fees. Now, based on such a comparison of overall costs, a unitary patent will be less expensive than a European patent validated and maintained in 4 of the 25 member states, so in 4 contracting member states, 4 being the average number of those countries in which European patents are validated at present. Consequently, the more countries a classic European patent would have been validated, the more cost-effective a UP will be. Now, let's go to up to 10 years. We have a difference in favor of the unitary patent of 3%, and it increases to 5% for 12 years, for 8%, for 12 years, yes, and 8% for 15 years, and 8% also up to 20 years. So if we take the first one for 5 years, well, or 10 years, it is 3%. So it is the rule of thumb saying that the unitary patent is slightly less expensive at the unitary patent than for the European patent for 4 countries. So let me wrap this up for you. The comparison is not straightforward. It's not one-to-one. We have a geographical difference. We don't know how many years the patents will be maintained, as it is an increasing amount from 0 at 1 year and a high amount on the year 20. And you will, as an advisor, you will have to look at the portfolio of your client. What is the average maintenance of the patents in the past in order to project something into the future? But the rule of thumb is clear for you now. 4 countries, 4 contracting member states, so the cost argument would be in favor of the European patent. Other arguments existing also as well. We will address them in a later video, but you have already some indications in the UPC videos which I made before. Thanks for tuning in. Hopefully this was helpful.